This is breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.
Petitioner or the plaintiff?
Good morning, Your Honor. The police of court, David Chesnoff, along with my co-counsel, Ashley Kissinger. Ms. Kissinger is from Colorado, Your Honor. She's also a member of 5 different bars. She's begun the process of Pro-Life Beach as the court knows. Got to go to the bar in the Supreme Court, so we would ask the court to allow her to appear today while the application is being processed.
Okay. Do you have any problem with that?
Remember, I knew that we were going to be asked that, and let me just say a couple of quick words. I have every respect in the world for Ms. Kissinger. She is a nationwide expert in media law. She appears throughout the country representing media entities. And I had a lovely conversation with her the last time we were in court, expressing my admiration for what she does. But we're playing fast and loose with a lot of rules. I don't think it's within my discretion to waive the rules. I have no expectation that she should not be admitted to practice before your Honor, but I just don't think it's my place to waive rules at this point. But I obviously recognize that the court is going to be inclined to let her speak.
I would also mention, Your Honor, that she's part of a firm that does have offices in Las Vegas. And
Joel Sassy, Your Honor, for the RJ as well.
I was going to ask who the other folks were at your table, but I don't see a motion.
So, Your Honor, we are in the process. As you know, we need to get we've been moving as fast as we can. We got the certificates of good standing. Today, it's being taken to the state bar for its approval. As you know, we have to go through that step. And then I expect we'll have a motion on file either tomorrow or the next day at the latest. So that's where we are.
And the court will recall that originally this was going to be heard on Thursday.
Right, I moved it up because I thought you guys wanted it moved up.
No. We want whatever the court thinks is in the best interest of figuring out a solution here. But I would implore the court, considering that all the steps are being taken, and her national reputation, I've been working with her now for over a week, Your Honor, and the court knows what I think of the court system and the bar, and she's about as good as it gets.
Okay, I understand, but unfortunately, I do not have a motion before the court, so I think you're going to have to take the rowing more on this one.
How about if we move for a continuance until Thursday so she can get it processed, Your Honor? Because it really kind of flipped things when we got to time change, and we understand the court schedule, but at this point in time, Your Honor, I would ask that you continue this until she's admitted.
Okay.
Your Honor,
Let me go ahead and have the folks on this side of the table introduce yourself.
Sure. Matthew Christian for the Las Vegas Metropolitan Police Department.
Good morning, Your Honor. Pam White on behalf of the State of Nevada DA's office.
Morning, Your Honor. Edward Kane and David Lopez McGrady for Robert Tellis, who's the defendant in the criminal case that provides the background for this.
Okay.
No, let me say one more thing about the Pro-Life Beach.
Sure.
I think a lot depends on what is the scope of this hearing today, because if we're here to talk about the unique difficulties with the jurisdictional issues, those are very unique to Nevada. I think it's fantastic that Mr. Chesnoff has now appeared in this case, because these are Nevada issues. If we're going to get into copyright law and whether there's some kind of ownership interest in materials that are contained on these tangible objects, which are the only things that have been seized by Metro, then Ms. Kinzinger would have, I think, more to say about that. But the issue really that we should address first and foremost is whether there's jurisdiction to even go any farther than today.
Okay. Before we even get there, and I read a lot of paper.
I told you she was good.
Well, I don't even think it's her fault. But anyway, I'm kidding. Okay. Can I just ask, let's just step back a minute before we get into jurisdiction or anything.
Sure.
Can I just ask you, what the probable cause is for the seizure of the phones? Meaning, what is it that you expect to get out of the phones?
Well, Your Honor, this is a very unique circumstance, right? The seizure that occurred in this case was not a seizure from a reporter. I don't think it should be thought of that way at all. Nobody from Metro went to the offices of the Review Journal and took anything. There was no search warrant for the RJ's offices. There was no search warrant for any of the individuals who are attempting to make appearances as plaintiffs in this case. The phone and the devices were taken after Metro was called to the scene of a brutal homicide. And just like they do in every circumstance, they seize the devices of the victim. This is the victim of a homicide first and foremost. So he happens to be a reporter, right? He's a victim who happens to be a reporter who worked for the RJ. The theory of the case, as everybody knows, is that his reporting is what led to his death. So the material on that phone is very uniquely material to the case.
What is it that you hope to get out of that? And you don't have to be really, I mean, are we talking emails, communications? Are we talking phone calls?
His whereabouts, who has spoken to him, and that could be inculpatory or it could be exculpatory. And that's why in this very rare circumstance, the state of Nevada is aligned with the defendant in this case. Because the way it always works in a homicide case is that these materials are seized from the victim. They are, there's images made, and they are provided to the state, and the state provides them to the defense. Because only the detectives in the case, only the prosecutors in the case, and only the defense attorneys in the case know all of the details and know all of the facts and circumstances, beyond just these devices. So they're the only ones that really know what they are looking for. But there is a warrant that was obtained to search the devices after they were seized. And the warrant states the probable cause. And I don't know if anything more can be added than what I've already said, but it's clear that in every homicide case, the victim and the people that he's spoken to, the circumstances surrounding his life in the days and weeks and months leading up to his death, that is something that has to be looked into a complete investigation as soon as occur.
Okay, so if I understand you right, I'm talking with counsel.
Okay.
You don't need any information about any stories that he is writing.
Well, I don't know that to be true, Your Honor, because again, he's a homicide victim who happens to be a reporter who the leading theory of the case has been killed by someone he was writing stories about. So the stories themselves are potentially material, and it's not up for the state or for Metro to tell the defense that some story that he might have been writing is not something that they're entitled to have, right? I mean, that's really the main issue that we're having here, Your Honor. That in an ordinary case, these materials would be offered to the defendant. He's demanded that these materials be given to him so that he has his opportunity to find anything in there that he considers to be exculpatory or impeachment material on any witness the state may end up calling. They know the theories that they're working on their case. They know other circumstances. So the demand has been made, and if these materials are not provided, there's always going to be this appellate issue embedded forever into the criminal matter, right? Because Brady and Giglio are very, very important Sixth Amendment rights, and there's libraries filled with case law about it. We cannot afford to trample upon those rights. We're talking about taking away the liberty of Mr. Tellis for the rest of his life. So embedding this appellate issue forever into the criminal case is really what we're really getting at here too. That's what we're getting at. And it's not just the defendant, right? If the RJ has its way and a special master is appointed and this protocol is entered, they don't even want the state to look at the materials at all. So we're talking about potential materials that are inculpatory, that the state may be able to use in their case in chief. So, my client has a duty, the state has a duty to run down a complete investigation, and the victim's devices are always part of the complete investigation. And I don't know if anything more can be added to that from the state or from the defense, but that's why we're here. And that's why we've reached this impasse, because we have to look at these materials, and the RJ insists that we cannot look at the materials.
Okay, so what I'm getting is that you want to know Mr. Fairman's whereabouts for the past several months, because it could be inculpatory or exculpatory.
Sure.
You want to look at whatever stories, if they're on these devices. By the way, we all agree that we don't know for sure what's on these devices, right?
That's right.
Okay.
We have an idea that there's information about investigative work done by Mr. German with sources, which is one of the major reasons for the seeking of protection here.
Well, that's what I'm getting at, is I just want to understand what we're really talking about here.
Right.
So we are not talking about his list of contacts. By the way, probably everybody in this room is probably on his phone as far as a contact, right? I may be even on there, for all I know. You don't need the contacts, do you?
Yes.
You do need them?
Yes.
Yeah, that could be, I mean, I'm not speaking for defense counsel, but that could be potentially exculpatory.
Well, and then I'm concerned about, are we talking about 30 years of contacts that you're trying to get? I mean, do you really need that kind of stuff? I mean, is it something that we can limit down as far as what is being taken? I mean, we don't need information about stories that he's doing other than what he's doing with respect to the public administrator's office or Mr. Tellis, right?
I don't think the defense would agree with that.
Absolutely disagree.
And why is that?
Because if you want to define what Brady is and what exculpatory evidence is that I'm entitled to, evidence on alternate suspects is unquestionably Brady material. Mr. German was a journalist. He was an investigative journalist, as we're reminded of every day in the newspaper since this happened. I accept that. The theory of the case is that he was killed because he was an investigative journalist by someone who was mad at him over his investigative journalism. If there are other people on that phone or on that computer that he was investigating, they are alternate suspects, and I'm entitled to and required to investigate that on behalf of my client. And you know, the court has said there's a lot of paper in front of you, and that's true. There's not a lot for me, because my position and my client's position can be summed up in a paragraph. We're entitled to Brady material. The police department and the DA have conceded that everything on these devices is Brady material as to my client. I'm not about to agree to anything that's going to limit my access to what the state and the police department have already said I'm entitled to, and I believe I am.
Your Honor.
Your Honor, can I say one more thing? But we all recognize that the media has very significant interests. No one's questioning that. No one's trying to undermine anything or obtain confidential source information for the fun of it. This is a serious matter. This is a homicide investigation, and there should not be any introduction of any appellate issues into it. The solution has been offered, which is a agreement like a protective order. A very limited number of individuals would be the only ones that would be entitled to look through these materials. I'm talking about the homicide, the couple detectives that are working this case.
The taint team?
Well, we've talked about taint teams, but that idea, we reached an impasse about that as well. I think that was offered at some point in the beginning, but a tape team isn't going to work because Mr. Kane cannot delegate his duty to look for the materials himself. This is not like other circumstances where there's a tape team, Your Honor. I mean, the 60 pages filled with all of these cases can be distinguished on some basis in every case.
Yeah, I will tell you, I was a little disappointed I didn't get a spotted dog case from either one of you on this type of an issue.
I mean, this has never happened before. I mean, we all recognize that this is a unique scenario. The reporter is the victim. This isn't where the reporter was investigating a crime that Metro was also investigating, so Metro wants to know what the reporter knows to help the investigation. That's not what this is. This is not a civil, half the cases that they've cited are civil cases. This is not a civil case, and there's no parallel to a civil case whatsoever, because the Sixth Amendment is not an issue there. This is,
Just a minute.
I'm sorry, maybe I'm
Go ahead.
going on too long. But tape team is used in circumstances where we take things, I think primarily at least, when we take things from the defendant. If we had taken things from any defendant and they make a claim that we are in possession of the defendant's materials that are privileged, then of course we need a tape team because we're not entitled to know those things that are uniquely the defendant's. So that's a...
But we are dealing with something that is unique to the reporter.
Sure, absolutely.
And the victim.
Right.
So, okay.
Thank you, Your Honor. Your Honor, I was brought in by the Review Journal not because I'm a First Amendment expert or lawyer. I was brought in because of the fact that my normal practice is criminal defense. And the reason that the Review Journal wanted my expertise was because we were dealing with this claimed issue of Brady. Brady is a recognized principle, but it is a recognized principle that the defendant is entitled to the Brady material as it impacts guilt and innocence and punishment. And the case law throughout the state of Nevada and in the Ninth Circuit makes it clear that as long as the defendant receives the Brady material in a manner which permits him to prepare for trial, not for a preliminary hearing, which is the stage we're at right now, knowing what the court knows about the fact that the Justice Court does not, by Supreme Court edict, get into discovery issues, the question of whether or not the Brady needs to be given now is misplaced. It doesn't. What needs to happen here, Your Honor, because I think everybody's talking about the Sixth Amendment, but they're forgetting that there's a co-equal amendment, which is the First Amendment. And it would be a terrible irony, Your Honor, that if the person who murdered Mr. Gurman were to force the Review Journal, which owns the property, they had a co-extensive right to the property, they used the property, they edited his work, they were in touch with him constantly. It would be a terrible irony, Your Honor, if the Review Journal were forced, without any judicial intervention and without an objective, non-law enforcement, non-DA person, which is what the case law talks about when they talk about a special master. This is done all the time, Your Honor. In federal court, for example, Your Honor, there were situations where people wanted to see a defendant's pre-sentence report, and because there would be valuable information in the pre-sentence report. The prosecution oftentimes would say no, and there was a federal statute which made the pre-sentence reports protected. What happened was the Ninth Circuit, in a case called Streifler, said the judge gets to see it in camera. The judge reviews the pre-sentence report. The judge then decides what's appropriate to be turned over to the defendant, to Mr. Kane's client. And in this case, we've asked for an independent, if in fact there's not an absolute privilege, which is one of the arguments that would have been made by Ms. Kissinger, but assuming that the court thinks that there has to be a balancing here, then the only thing the RJ is saying is the court should appoint somebody independent to review the material with experience and understanding what Brady is and what inculpatory evidence is, and then delineate the limited amount of material that'll be on those electronic devices that could even arguably be Brady material. As of now, there has been no offer of proof as to why they believe there's actually anything other than information about the person they've alleged to be the killer on the phones. Nothing. It's completely speculative. So what I'm saying to Your Honor is there is time to have somebody independent look at this material and then balance the First Amendment issue against the Sixth Amendment issue. One is not more important than the other. And the Review Journal is concerned about something very important here, Your Honor. They want to be assured that their sources are protected. If people in the DA's office or in the Metropolitan Police Department have an opportunity to view this information willy-nilly, they are going to discover the names of people in their department and in their office who may have been Mr. Gurman's sources. That will have a long-term, everlasting, chilling effect on sources and journalists receiving information from sources. So if the position of the DA and the position of Mr. Kane and the position of Metro is that it's okay for somebody to kill a journalist so that then everything the journalist dedicated himself to, his entire career, and the way that newspapers work, if that's what's going to happen, that's the irony, Your Honor, and there should be no irony here. This is a simple solution. The court designates somebody to examine this material and make a determination. It's going to be a minute, if any, amount of information. But Mr. Kane's client, the DA, Metro, shouldn't be able to see Jeff Gurman's entire life. That would be outrageous. That would be outrageous, especially since the property is still owned and controlled by the Review Journal. It's their work product, Your Honor. It's like an attorney work product. And so what I'm saying to you, Your Honor, is everybody all of a sudden thinks that there's got to be this rush for the Brady. And there doesn't have to be. In criminal cases all the time, judges take information in camera and study it and make a determination as to whether or not that material should be turned over to the defendant. And the courts sometimes don't give anything. I'm sure the court is aware of the fact that those in-camera processes occur all the time. All we're asking for is it be somebody who will be outside of the community where Mr. Gurman had sources. Because it's a very dangerous situation, Your Honor, if people sit in a room from Metro, from the DA, and just look at Mr. Gurman's phone and say, oh look, when they wrote that story about Mr. Wolfson last year, this is the person who gave us the information. The court doesn't want to see that happen. There are people in the courthouse that are sources. We all know that. There are leaks all the time. Drives me crazy. See, I mean, it does. I go, how the heck did they get that? So what are we going to do, Your Honor? We're now let the very people who are interested in who's leaking look at this for the speculative possibility that there's information on Jeff's phone that somehow will aid the defendant? No, there's a cure, Your Honor. There's a cure, which is to have the court intervene and tell everybody, this is who's going to look at it. When they're done, they'll issue a report to the court or to all the parties and say this is what's going to be given. And it's not complicated, Your Honor, but this concept that somehow Brady has to be done today is not the law. And one other thing, Your Honor, I have to say this for my co-counsel. If we are going to get into the merits of the First Amendment arguments or the federal laws about seizing the phones, and I would act on behalf of the Review Journal, have to say it would be a due process violation not to pause it in time for her to be admitted, or I can move orally right now, Your Honor, for her admission. She's gotten her certificates. She's in good standing. She's obviously a very knowledgeable lawyer. She's worked diligently on this, so I would either ask that we postpone any First Amendment or other substantive arguments until Ms. Kissinger is available, or in the alternative, you admit her.
Okay. Thank you. First, I'd like to discuss the jurisdictional aspect of this case. What is before me is a motion for preliminary injunction as well as for return of the devices. Okay. Judge Kroll already granted a TRO. I have concerns with it, by the way. I think it is extremely overbroad because it says to prevent Metro, the DA's office, the public defender's office from inspecting or searching any device seized from Mr. Garman's home. Devices can be electrical, they can be mechanical, so you can imagine what I'm thinking as far as how broad this is. That is the first thing I want to say. As I am being faced with a motion for a preliminary injunction as well as a motion for return of property, as far as return of property under NRS 179.085, I still think that I've got jurisdiction because the statute that you're talking about indicates that if there is no criminal proceeding, then it is treated this way. Well, it doesn't say that if there is no, you have to, if there is a criminal proceeding, it has to go to the criminal court. I don't read it that way. Okay?
I know that's what the cases say, though. And
Well, I think that if nothing else, I've got ancillary jurisdiction to hear the issue with respect to the return of the devices. The problem here is the RJ does not own the devices. Mr. Garman, or now his estate, is the owners of the devices. Now, we don't know if there's information on those devices. In fact, weren't there more than one phone? Wasn't it 2 phones?
just one more.
Just one phone? Okay. We don't know the information that is on the devices. There may be nothing on there for all we know. I mean, if I was a betting person, I'd say there probably is. More likely than not, there is. But we don't know, okay? That is the key. So I don't know that the RJ is entitled to a return of the devices themselves. The question becomes the information on the devices.
Just so the court knows, and we did present an offer of proof, the paper does pay the reporter a stipend to cover the cost of the phone.
A whopping $80.
Well, to a reporter, I bet you that's a lot. We don't really want the devices, Your Honor. We're interested in the contents of the devices, which we have we have an interest in.
Sure.
Because it's the work product, because for all the reasons the court understands. So getting the physical computer, the physical phone, that's not an issue. The issue is the contents and putting in place a methodology to preserve the confidentiality of the material until such time as a judicial officer makes a determination that there is something that the Sixth Amendment concern of Mr. Kane outweighs the absolute privilege that the RJ would argue. But we understand that this would be a balance.
Okay, I understand that. What I'm thinking about is a team, trusted members of Metro. Okay, I am thinking about that, and perhaps maybe coincide that with somebody like what you had suggested, Peggy Lean. The only problem is who's going to pay for Judge Lean's work.
In normal circumstances, Your Honor, I've been told that the court arranges for the payment. But if that's going to be an issue, Your Honor, I'm going to talk to my client and talk to my colleagues, and perhaps we can fashion a solution.
Okay, and the reason I'm thinking that now, I know you don't like the idea of maybe a couple of trusted Metro cops that would be appointed by me, or you could give me a list of names, see whether there's any problem there, but I'm thinking about that. And I know you may say, well, geez, they're going to get the information. We've got to trust somebody. And I would order them not to divulge any information that they get from looking over the devices. And then if Judge Lean, what's good about her is that I think wasn't she a public defender as well as a DA at one point?
She was the wife of a public defender, and later she was a public defender.
Oh, okay.
She was a AUSA, Your Honor, and she
Right.
was a magistrate, but having appeared in front of Judge Lean over the many years, I recommended to our client that she would be a satisfactory person.
Well, the reason
She dealt with all these kind of discovery issues and Brady issues when she was a federal magistrate, Your Honor.
Well, that's what I'm thinking, that the concern I had at first is that while she's been a judge, she's not really been an investigator, but if she was a DA, certainly she dealt with that stuff. And who knows, maybe she and her husband talked. And got information as far as the defense concerns. Well, she would understand all of that. But that's what I was leaning on doing before I talked with you guys.
No pun intended. May we confer, Your Honor?
Sure,
Thanks.
We can confer as well, Your Honor, but
absolutely.
I feel like I should make just at least a brief record on the jurisdictional issues.
Sure.
It sounds like the court's gotten past that. But just to be really clear, the case law that both parties have cited really inform us that there's only one court at a time that can have interim jurisdiction. And in every case that the party has cited, when there are two competing courts, the court that has the criminal case is the one that has to hear these issues because it's tied in with the criminal matter. So that's one thing. That's really the fundamental subparagraph 5 of 179.085. That statute was enacted not that many years ago. Maybe it could be written more clearly, but before, I think it's 2015, there is no subsection 5. So if your property has been seized and you want to get it back, and there was no criminal case, because, and this happens all the time, the investigation is ongoing and no one's even been indicted yet. It's just a suspect that the material has been taken from. So when that person wants their property back, there's no motion that can be filed because there's nowhere to file it. So with the legislature, that forced those folks whose property has been taken from them to go through elaborate measures like filing lawsuits. So the legislature corrected that and allowed this motion for return of property to be filed where there's no criminal case proceeding. In federal court, it's the same thing. If property is seized in California and there's no criminal matter pending in California, well, there is a matter proceeding in California, but the person whose property has been seized from them lives in Nevada, the motion could not be filed in Nevada, even though there might otherwise be jurisdiction or there might otherwise be able to state a cause of action, because then you're having a court in Nevada exercising jurisdiction over the property that's already the subject of a criminal proceeding. So that's that one issue, but if I can just briefly address the second jurisdictional issue, which isn't really fully briefed until our pleading yesterday evening.
I read it last night.
I know. Thank you. I'm sure, I was sure that you would. But the second hurdle really is the relief, and I think the court touched upon it. The relief is restoration of the property. However you define return or restore, it's got to go back. It's back to the person that it was taken from. And in this case, we're not even talking about the estate. If the estate filed a motion for return of their property in justice court, they would much more clearly have standing to do that. Here, though, we're mixing and matching this statute, this remedy, that remedy, trying to pull it all together.
We were putting a lot of square pegs in a lot of round holes. I
Absolutely.
agree with you there.
It is, and it's important to discuss this because it's jurisdictional, right?
Well, but you also have to remember that it was a district court judge that authorized the search and the seizure. And in my view, I believe I've got jurisdiction, if nothing else, on an ancillary basis. And I'm not so sure that the statute precludes me from asserting jurisdiction when the motion for a preliminary injunction's been filed here. I don't think NRS 179.085 precludes me from asserting jurisdiction just because there is a criminal matter in justice court where they're going to be dealing with a preliminary hearing. They're not really dealing with discovery and those kinds of issues. So you may have an appellate issue.
Right.
And I would be horrified if the 7 wives ones up in Carson City gave me some insight as to what to do.
Right.
But this is what I'm leaning to do, is have at least a couple of trusted Metro higher-ups to review the phone with the assistance of Judge Lane, is what I'm leaning with doing. Though the RJ is going to have to pay for Judge Lane if we do that.
May we talk?
Sure. By the way, I've got a trial starting at 9 o'clock in Homestead. So, and unfortunately, the business court matter took a lot longer than I thought it would, but welcome to business court. So, all right, why don't we take about a 5-minute break or so and let you guys talk, okay?
Thank you, Your Honor. You guys want to talk?
Well, you wanted 5 minutes.
Yes.
Was that enough time?
No. But I will say this, Your Honor. In an effort to slightly tweak the proposal that Grove is making, and I know the respect the court has for Metro, and I have respect for Metro.
I have respect for everybody in this court.
No, I
right
understand.
now.
One of the concerns, obviously, is sources within Metro. So our suggestion would be that rather than have it be Metro Police working with Judge Lean, that we have a police officer from homicide from either North Las Vegas or Reno.
Well, the concern I have is Metro's conducting the investigations, and the retained team from there would know what they're needing to prove. I mean, they're going to eventually have this information and hopefully exert what is the paper's interest versus what's needed for the investigation and parse out. That's what I'm hoping that will happen.
I understand, Your Honor, but I think it's a little, I'm not using this word.
Well, let me ask you this though, Mr. Chestnut. If you have someone from North Las Vegas, you may have the same problem. You may have, Mr. Garriman may have had sources at North Las Vegas.
Well, I think Reno's a better choice, to be honest with you.
Okay. Isn't there a relationship between the Las Vegas Review-Journal and the Reno Gazette? No business relationship?
None, Your
Okay.
Honor.
Okay, well, I'm still concerned about that, but anyway.
But I mean, I really appreciate all this creativity, and I know the court has read all the briefing. The defendant is not going to be able to agree to delegate this power to anybody, and because they can't, the state cannot, and because the state cannot, I cannot. So this is what I recommend, because we all know that one way or the other, we are going to have to get to the Supreme Court. I feel like what should happen, given the court's inclinations, is that an injunction of whatever the court thinks is the best course of action can be entered. We don't agree to it, and so I believe that we have a direct ability to appeal from the entry of an injunction. So that's what I would recommend, because one way or the other, this is going to have to get up there, and you might as well just do it sooner rather than later.
Well,
And in the meantime, of course, if we can, we've been discussing this with them since September 16th or before, so we can always continue doing that. But, I feel like it would be better for everybody just to let this be resolved one way or the other.
okay.
Finally resolved.
All right, this is what I'm going to do. I've got concerns on both sides of this. I mean, I appreciate we got a First Amendment and Sixth Amendment problem, and we don't have a spotted dog case anywhere in the United States. I get that. So this is what I'm going to do. Number one, I am going to grant the preliminary injunction, but we are going to have to tweak it in terms of talking about the exact devices that we're talking about. They will remain in Metro's possession. Metro's not going to look at it right now.
Right.
But we're not going to have inspecting or searching any device. It's going to be the specific devices in question. Because when I saw this TRO, I was like, oh my gosh, what do we do? Because, I mean, technically speaking, and I don't want to get into the weeds, if Mr. Garriman had a pocket knife in his pocket at the time, they would, Metro technically would be precluded from inspecting it. You know what I mean?
Your Honor, can you limit it to things with devices and instruments with information on it, like a dictaphone, a computer?
Identify what they are.
Okay.
I want it to be specific.
And we will submit to you, Your Honor, what we think should be covered. We'll share it with our colleagues.
And Mr. Christian, I think you can also, whatever was seized, you can identify what they are, and then you guys can limit what they are. I mean, as far as the electrical devices specifically.
Yes, they asked us to identify. I don't think they knew what devices he even had. They had to ask us what we have. And we, in good faith, told them what we have.
Okay,
And there's a list of 6. Now, recently this issue of a dictaphone came up. I don't know if we've run that down. I think we have run that down. We have no knowledge of being in possession of a dictaphone. I can check on that again, but.
I think we also asked for any notes and files that they seized that would have
And
information.
we've repeatedly said that we didn't take any paper. The officers did not take any paper from the home.
okay.
And we're comfortable. We'll go over a list and we'll transmit a letter to the court with a list.
Let me ask you this, Mr. Christian, because I certainly don't want to impede any investigation or confidentiality on your part. Would it be a problem to give the paper's attorneys a list of, the return? Is that a problem?
I don't know, I'd have to check.
You could do it under
I
a
think they're
protective
under
order.
seal.
Your
I
Honor.
think they're under seal.
Okay, one at a time. Go ahead, Mr.
I
Christian.
think all the warrant documents are under seal.
Okay. By Judge Jones?
I believe so.
No, as of yesterday, they were unsealed, Your Honor, according to the docket from the...
No, Your Honor. I was President of Justice Court yesterday. A single search warrant issued by Judge Balcom was unsealed and a redacted copy provided to attorneys for the Review Journal.
Okay.
But no search warrants have been unsealed at the district court level, to my knowledge.
Okay. Well, I was just going to say, if it wouldn't be any problem, and I would order Mr. Chesnoff and his team there not to divulge anything in the return, if you could show it to them, and then they can look to see what they're concerned about, and we can put that into a preliminary injunction.
You know, I don't know if I can agree with that, Your Honor.
Okay.
I have a duty.
I understand.
Candor to the court. I think I took it in good faith when they asked before, what are we in possession of, and we revealed it to them. So, if that means the injunction has to say, or any other similar devices.
I don't want to leave it wide open there,
Yeah.
because that could tie Metro's hands in terms of they want to investigate or test
Right.
something. And if they test something, then, oh, well, that fell within the penumbra of any other device. I don't want to do that. That's what's the concern I've got right now with the TRO I'm looking at on my screen.
Yeah, well, I can absolutely check and see what other kind of documentation we have that delineates exactly what was seized. I'll be
Okay.
happy to do that.
And by the way, this is a preliminary injunction. I'm envisioning that we're going to be dealing with this quite a bit. We all want to get it right.
We appreciate that, Your Honor. We will, so do I need to give you a little, we definitely need this order to say devices with stored information or something to that effect, Your Honor.
Well, I'm just concerned about that.
Well-
Stored with what? I mean, I'd rather have it specific.
Just, okay, we'll work on language and give it to you, submit it to you.
Or why don't you guys work on it together?
All right, we will. I have no issue doing that.
Okay. All right. Good luck, guys.
Thank
And then
you.
will this
Nice to see you.
injunction talk about petty lien and all that?
Not right now. I would like you guys to discuss what you want to do, but I'm leaning toward 2 trusted Metro officers that are higher-ups is what I'm looking at, or how many, I want to keep the number small, because the smaller the number of the taint team, the less likely we're going to have a problem about leaks, right? And, you may know people who leak information, but I know a lot of officers who don't. I mean, that could happen anywhere. It could happen in the judiciary.
It could happen in Reno, and it could happen with Judge Lean, for all we
Yes,
know.
exactly.
I mean, I'm not, honestly,
I don't agree to that.
I
I don't agree.
have the most respect for Judge Lean, but, she has staff. There's no guarantee.
Well, I'm just saying, though, everybody will be under orders. I'd like you guys to even craft an order if you guys can agree to that. But I want it to be Metro and Judge Lean if
Maybe Mr. Chesnoff can craft.
We'll pay for
Yeah.
Judge Lean if we can agree to the other parts of this, Your Honor. I don't want to mislead you, Your Honor. The idea of having people in Metro, no matter what level, is not acceptable to the Review Journal because of the nature of Mr. German's work. and the continuing work that the paper will do with the information that Mr. Berman has and had and was working on. So I really would like to try to think of an alternative to two higher up metro detectives or lieutenants or captains or whatever the court is envisioning, only out of a real abundance of caution and concern for the purity of the First Amendment argument here, Your Honor. The whole argument that's being made by the Review Journal is not being done to be difficult. It's being done because they are absolutely concerned that this could be a domino effect on their ability to investigate reporting. And I think that was the concern of the maybe 50 other media organizations that have joined in on this. This is a very sensitive issue as it impacts the newspaper. And so I'd like to think of somebody that the court could envision that could handle the taint part of this, that understands homicide, understands Brady. So we're going to continue to try to, when we talk to them, think about that. And then we will resubmit to Your Honor if we come up, if we can agree to something, and if we can't.
Do you want a status check on it?
Yeah, that would be good.
How long?
What do you think, counsel?
A couple of days, I guess. So, just so I'm clear, Mr. Chesnoff is going to draft a limitedly worded preliminary injunction that lists the devices, but doesn't get into taint teams or who's
Right.
okay for
What it sounds like you guys need to do is talk about it,
Yeah.
and then we can review that part in a week. But I want to dissolve the TRO and have a preliminary injunction in place that's more specific. Because
Right, okay.
I'm really, when I read that, I was worried about tying Metro's hands in their investigation. I really was.
Okay, well, we appreciate that, Your Honor. So we'll contemplate getting the form of a preliminary injunction to Your Honor that
As soon as
can be
possible.
signed as soon as possible. I
Right.
don't know why we couldn't just do that today, really, because it's very limited. It looks like the TRO, except for it'll have a list of the devices in it.
Okay.
And
Is there really a necessity for a bond?
Well,
It's their request.
I didn't have a chance to look at what the amounts would be in other circumstances. The only argument that we've made is that, I mean, there's no amount of money that would compensate the public if this leads to some kind of...
Well, there's already a $500 bond in place. We
Yeah.
can just keep that,
Thank you.
okay? And believe me, I get it.
Yeah.
When will we have a status on
You want a week? You want 2 weeks? What do you want?
a week, Your Honor?
A week?
That's fine, sure.
Okay, and understand, if you guys can't agree as far as the taint team, I'm gonna make the decision,
Right. Yeah, we understand that for sure.
okay?
Okay.
Okay,
Thank
we'll
you,
see
Judge.
you on the 18th.
Your Honor?
Yes.
That's the one day I can't. I gotta be in federal court in New York, so.
I request the
Lovely this
19th
time
as
of
well.
year,
Your Honor.
right?
Yep.
Okay, how's the 20th?
Perfect.
That's Thursday then.
Fourth, Your Honor.
You know what? Why don't I do this on a Wednesday instead? Is the 19th?
Yeah, I'll be back.
You'll be back?
Yep.
Okay. Because all of those are short, and I could have you guys come in at 9:30.
Great. Thank you, Your Honor.
Okay. Yeah, you won't
I'm
have to
sorry,
wait like you had to do today.
8:30.
9:30.
Thank you.
Okay? Because I've got status checks and things I got to take care of, mandatory Rule 16 conferences,
Yeah.
things like that. Okay.
Thank you so much, Your Honor.
All right, thank you.
See you.
You've been watching breaking news from the Las Vegas Review Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.